So the topic that I'm going to talk a little bit about is the other stepchild. And Abby did a great job with design patents, and I think Apple really brought them to our attention. There's another unique aspect of US law that other countries haven't honored, although they're sort of considering it. And that's this idea that if you're going to have first to file, which we moved to, is everybody familiar with first to file? Who knows what first to file is? Okay, we'll go into it a little bit. Let's start here. Do we know what a patent is? Basically, a patent gives you certain rights. And it's not the right to practice your invention. It's the right to stop other people from practicing your invention. So it doesn't mean that you can go out and make your product or sell your software. It means that you have a right to stop other people from doing what you have innovated. It needs to be, I have it down here, good, novel, new, useful, non-obvious invention. And perhaps some of the things that Abby just talked about with the curved sides, maybe that's not new if it existed before. Maybe it's obvious to do that for safety's sake. So you would have a much harder time to get a utility patent, sometimes referred to as a non-provisional. For the sake of this talk, because I'm going to speak about provisional, I'm going to use the term non-provisional, which really just means a real patent. And then we get into why would you do such a thing? Why would you go through all of the hassle, the paperwork, the hiring an attorney, the taking the notes? And really it's so that you can benefit from your invention. And we spoke about innovation and we spoke about incentivizing people. And the way that most people get motivated is when there's some benefit to them. And a patent's going to protect that because it allows you to reap the benefit from that. What a provisional patent does is allow you to claim ownership early on and quickly without a high bar of entry. And when the American Invents Act came into play, we changed. America has always been recognized as a place for the small invention. A small inventor, right? Not the large entity. But in fact, most patents get issued to really large corporations. I think we all recognize that too. Edison is still, I think, the most prolific inventor. Has 2,100 something. I know of some inventors that want to challenge that, and I hope they do, because they're really bright people. But the rest of the world was much more concerned with law and order. They want everything orderly, sort of the British banking lock and step type of a point of view. And for large corporations, there's also a benefit to that. In the American traditional sense, we wanted the person to use their mindset, get out and do it in their garage, bring it to bear on the economy, and then hopefully you'll benefit from that. And we had a few safeguards for that. One was that if you could prove you were the inventor, there was a process called an interference, and you could go forward and say, I can show from my notebook entries, from these date and timestamp things, that this in fact was my invention. And guess what? America would respect you for that and allow you to have the innovation. For the people that like to file the paperwork, they want to just know who got the paperwork in first. So maybe we can draw an analogy. It's not who gets the best paper when you're inputting something in law school. It would be more or less who gets it in first, and you're going to get the reward. And that is the law of the land now. And it's more in line with the rest of the world. In fact, I think it is in line with the rest of the world. I don't know of any other country that ever had first doing that. We preserve some rights if you were a practicing inventor and transitioning it, but those are probably going to go away. And so that if you were in fact an inventor and you were doing something, they're not going to stop you from doing it in the same location to the same magnitude. Where is that really important? Might be a little bit young for this set. Does anybody remember a case called State Street? Good. So he recognized it. There he goes. I have somebody else. Nice to have a few green
Not
beards.
that old.
Yeah, not that old. All right, not that old. Banks did not have patents. Very few did. It's a big statement to say they didn't have patents. Citibank had some. Citibank had a lot. Most financial institutions didn't have patents. And all of a sudden, this tiny banking system that aggregated all the trades in one day, put them by modem into one place, settled them out. I'm oversimplifying, but the idea was all the trades were aggregated and settled overnight. You needed a computer to do that. We don't do Pony Express. And they said that was valid, it was issued, and it was worth a lot of money. All of a sudden, a lot of banks stood up straight or sat up straight and said, oh my God, we're vulnerable. They've had all these systems they've been running for 20 plus years, really sophisticated systems, things that were required by the government, know your customer, things that are required by them, know your customer so you can sell to them again, new products, derivations, Black-Scholes, all these systems, really complicated things. And there's a bar in the US that says if you've been using something commercially for a year, you can't patent it. So now they're in a quandary. We can't patent it, other people can patent it, we've been using it, and they went hurrying down to Washington, and Washington said, okay, if you've been using something, you can continue to use it in the same general volume, in the same general areas. And that still exists today too. But by and large, my point was, we have moved now to first to invent, and because we're first to invent, as I'm going to conclude later on, you want to file early and you want to file often. If you're a very large company with an almost limitless budget, then perhaps you want to do non-provisionals. It's the right thing to do. Most people don't have endless budgets and time to do that, and so the provisional is also rising in its popularity. Why do you need a patent? I think this has been gone into a little bit here. You're going to commercialize a product. Apple. It's a great example. You're going to bring something to market. You don't want people to compete with you, and so you want to draw as big a circle around you and protect as much of your innovation as possible. Make them be different. Make them innovate on their own. Every industry there is going, right? From Cisco, huge one, telecommunications, obviously the automobile. Most people are familiar with the movie with the guy with the delayed wipers. Terrific invention. Auto industry looked at it and said, that's a terrific invention. Thank you very much. And they all put it in their cars. And of course, he barely had the money to sue them, but eventually got investors and was able to succeed to get his due. If you're going to commercialize a product, you want to protect yourself. You want to block competitors. You want to monetize your knowledge. And that's a new type of term that probably existed very rarely 10 years ago. But what is it that America does today? More than anything else, what's of value to us is what we know, and what we think and what we design. Most products are not made here, or the percentages are certainly dwindling here and rising elsewhere. So what is it that's so valuable to us? It's what we know. The way to protect that is that you need to trademark, code, you can copyright, but patent is probably still the most valuable as far as monetary needs. And I was touched on a little bit, gain investor confidence. You know, there's three rules. I work a lot with smaller companies now. It's wonderful, the diverse. By the way, anybody that likes people and likes how things work, you need to consider patent law. It's the most wonderful vocation there is going, because people will tell you their best ideas on a regular basis. If they have 10 ideas or 20 ideas, they're going to come to you with the very best ones and say, can you help me with this? And you get to help them. And it's a very creative side of things. There is patent litigation. Most of those litigators are not even patent attorneys. The patent attorneys are on the creation side versus the adversarial side. Very positive experience. Probably one of the very few areas of law that at the end of your day you can really feel good about yourself because you've had a lot of positive experiences during that day, right? Most of law has to do with people fighting And so you get to be on the good side of things. But when it comes to investors, does anybody know what the 2 cardinal rules investors want to know? That's the second one, the profit.
How safe?
How safe, how do I get my money back, right? How safe is it? And the second rule, I heard it over here and I may have heard it over here, how do I make money? And so what you need to do is tell them, you're going to get your money back because we have this great idea and it's worth something and they'll get that and we're going to protect it. And then you're going to make a lot of money because we're going to go license this or we're going to sell, a gajillion of things. The provisional patent, and I'll get into this a little bit later on, can actually extend the period of protection. And this, some people will call strategy and some people will call a gimmick. But if you put provisional patents in place and you're not going to have a product coming to market right away, you can actually gain protection for 21 years. And if you put it in place and you follow it up, instead of going immediately to a national application, say with the US, and you file a PCT, Patent Cooperation Treaty. Is anybody familiar with that? I know these 2 guys are. It's basically a treaty with most countries in the Western world. Taiwan was excluded so that China would be included. They wouldn't partake if Taiwan was in there because they just can't recognize them. But you have 30 months then to file. And the reason that becomes important is for a very low cost, you've just extended your patent protection by 4 years. And if you've ever dealt with the FDA or some government, and there are separate rules and some concessions that they make for that, but if you need to deal with a government agency in order to bring a product to market, extending that protection can be really important. In particular, if it's going to take you a while to get that product to the market. And so one of the things that the provisional will do is for a very little amount of money, will add another year onto your patent. That could be worth a lot of money, in particular in the drug industry. And of course, you want to develop company assets. And that goes back to my earlier point, and I repeat myself. What's of value in most companies in America today is what you know. And that could mean your customers and your markets and that sorts of knowledge, but mostly it's what is your product. And you'll have it made somewhere else or have it made for you. They'll outsource production most of the time. And so you really want to create assets. And if you're familiar with RIM, it came up today, they were probably, well, who knows. It could be that they're worth more dead than alive because their IP is going to be sold and it's worth a lot of money. Nortel is another one. And Motorola's also received a lot of money for their patents. IBM continues to generate and regularly sells tranches of patents, $1 billion at a time to Google. Develop those company assets, that's what they are. Return on investment, research and development. I could give you a whole day seminar on this if you let me, and I won't, and I'll keep it low. Who does R&D today? And who? Universities. I heard a little bit from Abby from FSU, and I need to make a trip out there. My daughter goes to school there, and I didn't realize they were so innovative. Universities, some companies, mostly small companies. We've become a nation of startups. And if you look at the labor statistics on where people work, then you're going to find that there's more and more there in small companies. There's a great website on maps of the world, and one of the maps is internet usage, and it's amazing on where it lights up. And the US is still very, very bright. The other is where do PhDs do research? And the US is still very, very bright. But where they do their research has become more and more for smaller companies. And every major company has cut, well, that's a big statement, I don't like absolutes. Every major company I know of has cut R&D budgets. And the big labs that America was built on have transitioned away from us. Westinghouse, Bell Labs, GE is tiny. IBM, great kudos to IBM. They're wonderful. 3,000 PhDs, continue to have the largest private research and development, and they're growing. If you go up to New York, and they now have, I think, 9 research and development centers around the world, they've begun to partner with other people because they do not want all research to be put into the hands of government only. CERN is quasi-governmental, also a wonderful organization, but if you go up to Yorktown in New York, there are more scanning electron microscopes on one floor in Yorktown than any place else in the world. And they're not all specialized, not all, many specialized, you know, vibration proof, sound proof. You go into these rooms, it's just an incredible place. But I can only name one of those. So who's going to do our innovating? I just told you our economy is now based on what we know. The big companies have drawn back on their R&D. So we need to innovate, and we need to find a way to do it, and we do that with startups. Startups are notoriously short on cash and big on ideas. Provisional patents are perfect for that. File early, file often, get somebody to pay based on your filings. I don't know if I should even go into that. I saw the troll, so I will a little bit. The big companies now, what they've done is reduce their R&D and then try to demonize those that have developed, even if the reason that they don't make a product, I prefer the term non-practicing entity, or the person that generates innovative products, and they're selling innovation. And so what do? We call them names. Where did that come from, troll? These people have an asset that they're trying to make money from, and they're trying to stay alive so they can generate the next innovation, and we're going to call them names, and guess what? We get lobbyists to take this to Washington, and they're thinking about changing the laws. They are changing the laws to actually kill the golden, the golden goose that lays the golden eggs. We're going to penalize the people that are doing the innovation. Probably not a good idea. When they have to, big companies buy small, innovative companies. They only buy them if there's enough IP that it makes it very difficult or impossible for them to practice what the small company's doing. Otherwise, you're going to get the proverbial thank you. So you need to avoid the big thank you. Thank you very much, that's a great idea, we're going to do that. How can you change that? Glad somebody got the pun. I saw a laugh. Okay, we get to some of the dry stuff. How do you do it? USC 111, what can you do? This is straight from the PTO. It's fast, or it can be, and it's inexpensive. You don't have to have formal patents. This is where you get to copy your notebook and send it in, if that's what you want to do. Get an early effective filing date. You can file a later non-provisional patent, and allows the term patent pending, which again can be important. Probably a little more substance for those that will do due diligence. To Abby's earlier point, provisional patents will be scrutinized, and hopefully whoever's going to make the investment will have someone like yourselves do some research and say if it passes the test, is it innovative? Is it novel? Does it work? Is there enablement? The provisional patent can be used for all of these things, and at the rapid pace that we operate in today's startup world, it's probably prudent to do these things, how do I put it? You want to have a roadmap on where the company's going. Right behind that, you want to have a roadmap of the innovation they're going to develop and why that's going to be worthwhile to the company. And right behind that is a roadmap on how we're going to file these provisional patent applications on a timed out basis so that you're right behind the creation of the innovation. If I were to guide investors, and I do, one of my biggest clients is a man who acts as a CFO for startup companies. And he calls me because he says, I think I have this great company. Can I invest in them? So he's asking the IP attorney, can he invest in them? And basically it's for me to answer the questions, Steve, I can protect your investors. And the only way we do that is to have a plan. One of the best plans is to use the provisional patent application. Why? It's fast and expensive. Nobody looks at the claims at this point. Do we know what claims are? Go into that a little bit, so I see some heads nodding. And the claim is where you follow up on the description of your invention, and you need to describe it well enough that someone else, schooled in the arts, that's the term that I think you saw in the last one, can look at that and actually practice what you're trying to teach. So they can look at your patent filing and they can enact it. It doesn't mean that you have to describe what a nail is. They'll take for granted that if you're a carpenter, you know what a nail is versus a screw. But someone schooled in the art should understand that. And so if you're a programmer and you're using language that says you're going to go out and have a call and the call is going to execute on these bases, they get that you're schooled in that art and you're going to understand what that is. Same thing with biotech. There's a really good reason I don't file any patents in biotech because I don't understand it. But somebody else schooled in it will.
You could be a Supreme Court justice.
I often thought that to be a district court would be wonderful. The percentages are you very seldom get overruled. Your own little kingdom. So all these things I think I spoke about a little bit. This one is actually really important. And as I go into how small companies work, but it works with big companies also. This is an official record of your invention. I am in possession of this as of this date. Why is that important? Other than to say you're first to invent, we just decided that's not as important anymore. But I did touch upon something else, and it was outsourcing. More and more, the business world today calls on other people to come in for a short duration of time and perform some services for us, right? Who's done that? Who's ever been a contract employee for somebody? Nobody? All right, we got a couple of hands. And the idea is you come in and you participate and you may be required to assign over your rights, but it becomes a little gray on what you contributed and what the people originally were in possession of. And it's even more difficult if you've entered into a joint venture. Typically a joint venture works something like this. I bring this to the table, you bring this to the table, I own this, you own that. What we do together, we both own. And so you get together and you have some sessions and you describe what this guy owns and you describe what this guy owns. But you can never go through the detail and say everything that he owns. It's just physically impossible and it's not effective. So now you work together for a while and this guy gets an original idea, thinks it up on his own. But guess what? This guy thought about it a year earlier. So who owns it? This guy might accept that when this guy says, oh, I thought about that. Might accept it the first time, might even accept it the second time. If you do it often enough, the second guy starts to get really suspicious of the first guy and say, how could you have, you say you thought of everything that I think of. And the way to prevent that is to file first, file often. Write it down, send it in. If this guy sees an earlier date, strong fences build great neighbors. We both know where the dividing line is. And so it's actually a cooperative way to say, this was mine before I met you, and even though I presented my idea and I brought you to the place where you would have invented the same thing, it does in fact belong to me. Again, if you have the budget and you have the staff to do a full utility patent, God bless you, you should do that. But very often we need to be fast on our feet, and that's where provisionals come in. You can also combine several provisionals into one utility. And there are, for instance, drug companies that will file on a regular basis every 2 weeks, every month, just on the progress they've made based on clinicals and trials, or they'll have a whole lot of samples where you have these machines where they're putting all the things into the trays, and every week they'll file on what they have, because they don't know which one's going to end up being the winner. I don't think I'd be giving it a fair shake if I didn't say, why not file a provisional? And I've touched on it. People tend to rush in providing complete disclosures, and then they get complacent and don't go back and follow up and make them complete. This often happens in symposiums or any marketing. People will send a slide deck and say, there's no NDA, I'm going to go out, I'm going to present this, or I'm going to try to sell this, and we're going to get into that a little bit further on down here. This is what I'm going to say, and lots of practitioners, and I've done it myself, you put the virtual staple through it, you put a background, you put some, I always put claims, even if they're not required, and you fast and dirty, it gets sent in, it can be done in an afternoon, and it gives them some level of protection before they go out and disclose this and make it public. Do we understand that once you make your innovation public, that in many areas of the world you forfeited that? And I think it's in this presentation. The US will provide you a 1-year grace period. After a disclosure or a commercial use, you have up to 1 year to file for patent protection. The rest of the world, once it's disclosed, the deal's off. Because what is a patent, really? A patent is a deal between you and the government. You give me your best idea, let society benefit from it, and I'll give you a monopoly for a short period of time. So I'll let you own that idea if you let society benefit. That's the deal. If you go to Europe, they drive a harder bargain. They say, you don't have anything to give me anymore. You've already made it public. Deal's off. They're talking about a 6-month grace period. They've had some meetings about it because, quite frankly, the amount of innovation is falling off a little bit in Europe. Wonderful learning institutions, really bright people, but their innovation isn't coming like it once did. And so they need to motivate them, and so they're trying to make it a little more incentivized for them to do those kinds of things. Another reason, if you really want a patent, because people are going to infringe imminently, this delays it. Remember that great strategy I said on how to delay filing and make it 24 years instead of 20? If it's imminent that, or people are practicing it already, you want to get your application before the examiner as quickly as possible. So you need to be aware of that. You want to make sure, and there are even accelerated vehicles so that you can file and have an answer within 12 months, also fairly new, really good aspect of the AIA. So if someone's out there infringing and you have a patent filed, you can turn that around, get an answer within a year on whether or not you have a patent. Once you have a patent, you can stop them or license them. You have 12 months to follow up. You need to schedule those things. You don't want to let these things go expired, right? Provides a priority date. I'm not sure why I put that on not to do a provisional patent. It could be important in some respects in litigation, I suppose, and the record of the invention. There are some cases where someone was sued for infringement, delayed discovery, a lot of stalling tactics, but they had this patent filed that was very detailed, and it was a very strong indication that they were infringing the other guy's patent. So there are, it can be a drawback a little bit in the sense of you're going to quantify what you're doing in an official way. It doesn't necessarily mean you're doing it, but it does say you were in possession of that. That can also work against you. There's a case, and it does happen, I suppose, people steal other people's information. In this case, it was a patent attorney. Has anybody heard of this case? Guy's looking at it and he says, this is a great invention. He calls up his brother and said, you got to see what I'm looking at. Sends the application that he's supposed to be working on to his brother and his father, and they file an application and get it issued, and sue the company. There's a place in this world for stupidity, and even if it's just that we get the groan, but it does happen. It happens to consultants. And a former attorney, so you hope. So, you need to be a little bit careful with that. I think I went into this a little bit out of order. The purpose of the patent. Who are the inventors is also very, very important. In particular, if you're dealing with foreign entities and their laws are going to be different. In that case, sometimes California is a foreign entity. Sometimes their laws are different. A lot of rights are reserved. Best thing you can do is have it written down that if someone's working on your project, they have a duty to assign or not. But be very clear on that understanding. If you're in a JV, it's okay if they need to assign to your JV partner. If they're working for your client, strongly recommend that they have a duty to assign to your client or to an IP holding company, but know what they're going to do. Because when things are small and there's not a lot of money involved, a lot of things are done on friendship, on goodwill. As money becomes involved, things change. So know that. Who are the inventors? Have or will the inventors assign? Even for the provisional patent, and the reason that it's actually in this presentation is that, well, let me ask the question. Who knows what determines the inventorship of a patent application? We're gonna have some people out there. I know he will too. There's only one section, and that's the claims. So you can have this whole treatise on how to do something, how to build something, what it looks like, make great drawings. But at the very end of the document, you say, here's what I claim as my invention. And there can be several sets of these claims, and they can be different things. It was touched on, a method, an apparatus, a composition of matter, those kinds of things. You need to look very carefully at the claims and ask yourself and ask the people involved a but-for question. But for my participation, would this claim be written? If you can't specifically say yes, and here's why, you see this part, that part was my invention, chances are you're not the inventor. If you do say they would not have that one element, then except for my participation, you're an inventor. And so you need to be very careful about that and make sure that whoever is an inventor, you have considered and hopefully had them assign, or rewrite the claim to take that part out, if you can do it. This is a similar thing, and it's related, but it's a great idea to bring it up to your clients. Hopefully you're doing some research as you're writing patents for them, or you're involved in an IP strategy. It's a great idea to know if they're going to actually be able to practice their invention. Again, other people can have related inventions. Let's say, let's go to Google and Apple. You can have a cell phone, and you can have, you license Apple for all those nice icons and the design of the case and maybe how the software works, maybe even some of the functionality. And then there's some company called Qualcomm that has this patent on how this phone actually works. So they think they have a great deal. Now I'm all ready, I go to sell the phone, but guess what? Qualcomm has patents on something else. You want to know that and tell them. And I just made that up as I went, and maybe it's a little far-fetched, but not that far-fetched. Do some background checking, let them know what's out there, let them know if they're going to be able to actually practice their invention. We talked about the grace period, we talked about the EU grace period. We didn't talk about confidentiality agreements. Who's written confidentiality agreements or signed one? Certainly you've signed them, right? It's very, very commonplace to say, I have a duty to keep what you tell me confidential unless it becomes publicly available. If it becomes publicly available, I can use that information just like every other person on this planet. Makes common sense. Almost every agreement has it. If I file a patent application and it covers what I've disclosed to that person, it's going to publish in 18 months. There is a vehicle if you file only in the US where you can request that they not publish it. But by filing a non-provisional patent application, you're essentially going to nullify that confidentiality agreement in 18 months. If you file the provisional, it's not going to do that, or at least it's going to give you more time before it does that. If you follow up with the non-provisional and the people in the front row will tell me they're still going to publish in 18 months. And if you follow up with a PCT, it will publish as soon as they can do it. And I don't know if they'll do it by 18 months. But the provisional application won't do that on its own. So it allows you to delay that decision until a point where you can say if that makes sense to you. Another reason for completeness, and something to look at more in the provisional, because the provisional is often hurried, and it's not done with the formality that a non-provisional is. Non-provisional patents are usually filed with checklists, right? Have we done these things as we go through it? Provisionals are done, like I said, sometimes in an afternoon, sometimes with photocopies of an inventor's notebook or a design. Often designs now are done sketched out on the flat pads. But you want to make sure that you're acting in a way that's at least complete enough to anticipate somebody else who's doing. Anticipate is the legal word to say, I have the invention first. And the law for 102 says that it has to disclose each claim limitation in a single document. A wonderful thing to do. And it's very powerful at giving you the freedom to operate and stopping someone else from getting a patent against you. And really, it's in this presentation to say, exercise some discipline when you're submitting these things. Otherwise, you're going to give people a false sense of security that they've covered their invention, when in fact they haven't. Things get happening really fast. Often with small companies, their minds are in a lot of places. They have to manage skeleton crews, they have to go after investors, they have to develop their product, they have to do marketing. IP isn't always at the top of their list, and that's going to be up to you to make sure that you've guarded their back. And so I really hope that you give that some thought. It is okay to incorporate by reference. In fact, for a provisional, I would recommend it. But you need to do it in a way that also makes sense. You need to be very particular about what it is you're incorporating about it. So you could say, this circuit is built using this design tool. It can be found here in this publication or this software, or it was done in this type of a process as spelled out in this patent application. Always include the words that it's relied upon and incorporated, and it's incorporated by reference in its entirety, in which case you can add an awful lot of bulk to your provisional patent application just by pulling in the previous writings. But you need to do it the right way. Oh, so here we go. Oh, I forgot one. So remember what they are. How do I get my money back? How do I make money? And the other thing that there are, people, especially today, more and more want to know the social implications. And some people will say that, we've long exited the industrial world and that we've actually exited the information age, and now we're into the application of knowledge. And that there's a moral and ethical consequence to how we apply this knowledge. I don't think that anyone here will deny that we're into an age where we know more than any previous age. I forget, but it's more frequent than once a year. We now double the knowledge base of humankind as a whole. So everything that we've learned previous up to this point will be doubled within a year from now. That's a lot of power. There's social implications to that. And so investors, it'll be third perhaps, but they will be interested in the social implications. Because patents are more and more a part of due diligence and an important part for due diligence, they're becoming quasi-marketing tools. That first question I asked you, why are you getting this patent? Really important question because it helps discipline as you write it. But part of the reason you're getting it, I think we've all decided, is to impress upon the money people that this is a good idea. And if they're going to read that, you want to make it quasi-marketing. I think you'll find that patents from the 50s and the 60s and even the 80s, very dry. And we were known sort of as the nerd attorneys. But now we're becoming more and more known as the vital attorneys. And so don't forget the social implications of what you're writing about. It's a wonderful forum for you. Of course, it means that you need to be better integrated with your clients, understand what their business is about and why they're doing it. We went through most of this. File first and often. I'm not going to say that enough. If there's one thing you can walk away from here, file first and often. And it'll benefit your clients. Collaborate with your clients. Also a spin-off of the way R&D is performed today. Smaller companies have smaller budgets, and each one brings a piece. And it's a wonderful time for people to collaborate. It's a wonderful time for universities to collaborate. And the person that can help organize that and bring the people together is very often the IP attorney, because you know so much. You're sort of the hub in the middle of the wheel. Everybody comes to you, and obviously you can't disclose the other people's innovation, but you can say, you really need to speak with this other group over here, because they have something that's going to benefit you. And so how that affects the provisionals, I'm not sure, is a direct implication, but we really encourage you to do that. Have a purpose for everything you write. Before you sit down and say, what is the purpose of this document? And then make sure that it comes through. Matter of fact, I would write it right at the top of the page. Plan of execution is also important. I spoke about that a little bit, where you put right in front of the client, this is what we're going to do and the time we're going to do it, and I'm going to come looking for this information on this date. Helps keep everybody disciplined. In essence, you become a program manager. And this part I'd like to put in. It's a very, very complex world that we live in today. And the issues become more complicated, and they're going to look at everything you do. Whatever you do is permanent. And that wasn't always really the case, but with electronic searching and the record finding, it's also a warning to be careful about how you store your records, especially if you're going to store them in the cloud, especially if you're going to use something like Gmail or all those other wonderful tools that they have out there. Guess what? Read the terms of use for those things. And I would really encourage you, as an attorney, do not ever use any G anything. Because they say right there, we're going to go through your stuff. And they're going to go through your stuff. Even if it's for the frequency of words or the association of words or all these other things. Get your own proprietary storage. But also be encouraged, because it is also easier to file. And I'm looking at Rich back there, and I'll bet he'll agree with me that 10 years ago, it was much more difficult to go through the process. You had to run down to the post office before midnight. It had to be on this size paper. It had to be this sort of typeset. And if you forgot anything, you didn't find out about it for 2 months, because they had to open it up, read it, write something back to you, and put it in the mail back to you. It could be that 2 months later you're too late. So things are immediate. They tell you right away whether you submitted something that's sufficient. You get a serial number. It's easier. The market for knowledge is large and growing. This is what we sell today. And it's also a wonderful forum for innovation. Everyone now can be an innovator. And actually, the capital investment for generating IP and for filing for IP is relatively low. In particular, if you compare to somebody in Edison's age or things like that, he needed and required manufacturing plants and capital investment for machines and people and resources, and that's just not the case. One of the reasons that we have so many small companies is because we can. People can get small loans and go start a company for 6 months. So be encouraged, there's going to be an awful lot of it. And I think places like FSU are the perfect place for it, because you know what? Ivy League schools are not nearly as innovative as some of the schools that are a little bit lower. The people that have a drive and a need and a hunger, if you will, they tend to end up at the schools that are not the top tier. They can have breakthrough innovations and wonderful thought processes, and I don't mean to put it down. I have a Harvard 2 degrees. My partner in the consulting company is a Harvard graduate, wonderful, bright guy. But if you just look at the statistics and the numbers, it's often the second and third tier schools that have the people that are hungry and going after the innovation. Contact information, I actually put this one down because it's local. This is the consulting company. And I won't leave that up there for too long, but the idea in this world, and I touched upon it a little bit, intellectual property is limitless. It's not a net sum game. So you don't need to be adversarial per se. If somebody's stealing your stuff to do, and we need good litigators, and I work with them every day. As a matter of fact, I was late today because we filed suit against one of the very biggest information provider companies, and it was a really exciting day for me. We weren't supposed to do this today, but we did. And it was a small company that was literally put out of business after talking to this large company, and they literally looked at it and said, that's an incredible idea. And they threw a whole bunch of money at it, and 60 people lost their jobs. And this guy survived it, and he filed suit today, and I just can't wait to see how it turns out. But the reason for the consulting company is because it's not a net sum game. It's nice as you come in and you help people organize their company, organize their IP strategic plan. You become a project manager, you become a conduit person. part of what you do will be practicing law. The minute you file something with the PTO, that's practicing law. But a lot of what you're going to do is to be a counselor and a project manager and a CFO if you need to, and what makes sense financially. And as we create, we realize that I don't even really care which law firm gets it. I'll create the portfolio and hand it to any law firm you want, because there's always more, either in your company or the next company. When you're creating wealth and creating innovation, there is just no end to it. So if I leave you with two thoughts. The first is file first and file often. The second is there is no end to your career when you're in the innovation side of things. Human beings will never stop. And the more you help them, the more they'll create and the more work there'll be for you. All right, who has questions? Anybody? And where am I at time? Ooh, sorry. Do I need to get off the stage?
No, you're good.
Okay. Yes?
No. My name is Thomas Allen Selvig. I have a number of patents.
Good for you, Thomas.
I'm an inventor, Thomas Selvig, and I have inventions in the middle. This is very important to me.
Yes, it is.
And I'm a fairly bright fellow. However, I'm not a lawyer, and I have to deal with attorneys.
I'm sorry to hear that.
When will this DVD or computer link of this presentation be available? Because I can't process it fast enough. I'm going to need to review it.
I understand
So
that.
I know this is being taped.
Nita, can you answer that? There you are. Thank you, Nita.
It will go up on YouTube within the next 2 weeks. We need time to edit and process every presentation, and we can send out an email if you'd like to provide us with your email address. There will be a link to all different presentations throughout the day on YouTube. We just need enough time to process them, and we'll just make them available.
Okay, thank you.
Keep inventing, Thomas. Can we edit that last part about me filing suit today? I didn't know about YouTube. It's all right, it's fine. Okay, oh, yes.
So with the provisional patent, I agree that, in the hands of an attorney or someone in the know-how, it can be a great tool. But in my limited experience, and please share yours, I see that it often can be the downfall of a startup company or a starting inventor, because it is easy and they forget about it. They go over the 1-year mark and then they're done.
Good for you.
So what have you seen out in the real world of how the provisional actually works in the startup scenario?
It depends entirely on their guidance and how well the people are at keeping track. Most provisionals, quite frankly, I think are let go. And I don't have a statistic for that, but in my experience, that's the case. But you're absolutely correct. You don't want to build in a false confidence. You want to do the follow-up. It's very useful in some respects, but it doesn't mean we can be undisciplined. So your point is well taken, and it's probably the biggest downfall for the provision. Make sure you do a good job. Make sure you do a good job with anything you put your name to. Yes, sir.
You keep mentioning file first, file often. By filing often, you mean modifying your initial
Yes.
provisional?
Yes. Assuming that you're moving forward with development of either your business plan or your product, you're going to learn things. And almost every situation that I've ever been involved with, we can file right up front what they call a constructive embodiment. So even if it's not built, it's based on scientific fact. This is what we're going to go out to build. It used to be that people would wait until it was built and working on their desk. And probably not a good idea these days because of the first to file. So what you want to do is file it as best you know how. But as you begin to build anything, you'll find out, you know what, I thought that this would be the best way, but for these reasons I'm going to go a different way. Or I found out that I could also do this 4 different ways. I'm going to choose one, but you want to protect all 4 different ways because you want to stop your competitor from doing any of them. So the idea is as you gain more knowledge, file again. For a small inventor, the filing fee is $130. For a micro inventor, which is very narrowly defined, it's half that. For a large company, it's still $260. It's still a relative bargain.
Kind of a question then, just getting back to the very basics. A long time ago, I was told if you had an idea about an invention to send a registered letter to yourself with that information in it. Don't open it, keep it as a record. And now I'm hearing that all you have to do is write your idea down, get it notarized, hold it at home, and you are the first. And if the question comes up, the idea of who has the first date is the one that actually has the priority.
Thank you so much. You know, it usually does come up, and people need to understand that's what the law just changed. Is people have this feeling that if they can document, I was the first to invent, I own it. That's no longer the case. Now it's the first one to mail that letter to the PTO with $130. And that's what they call first to file. It's no longer first to invent in this country. That was what America was about.
Did you say $130?
For a small entity, provisional filing fee. Am I wrong? I think that's correct. It's close. I believe it's $260 for a large entity, $130 for a small entity, $65 for a micro entity. So if it's your first patent, then you make below a certain threshold.
Another question.
Sure.
Okay, you've got to the point where you filed. Once you receive the receipt back that it's been accepted,
Mhm.
I understand also that on your initial filing you say do not publish. That way it doesn't get distributed all over the world and so people start looking at the date.
Good for you. You really are researching this, aren't you? And yes, you can, there's a request for non-publication with one implication, you're not free to file all over the world if you
Right.
check that box. And many small companies or small inventors can't afford to go international anyway. That's going to cost you tens of thousands of dollars. If you're going to file national, EU alone is more than
Okay, once you
$10,000.
get your provisional, at that point, you're safe, I'm assuming, to take it to a patent attorney and say, can you process this further for me? Or what do I need to do at this point?
You know what? I get mixed reviews on the next comment I'm going to make, but for you, I'm going to say it. And for anybody else here. There's a terrific book called Patent It Yourself.
Yeah.
And I used to teach classes on it. And I still teach young attorneys because it does a great job. But to his point, you don't want to become too reliant on it because there's a lot of pitfalls when it comes to the point of the non-provisional. Even in the provisional. You can say things in the provisional that will be a permanent part of the record, and you need to be careful. So my advice would be, get the book, read it, write it, but bring it to an attorney if you can before you even file the provisional, so they can at least spend an hour and take out anything in it that you really don't want. Have them edit it.
Does a provisional need to have sketches or a picture or artwork with it?
Again, he's brought up a great point. It doesn't need to have anything.
Okay.
Well, it's supposed to have a description of your invention.
Sure.
But if it does not, it's not going to do you a lot of good.
Right.
So the more description, more enablement that you have, to his point, the more complete it is, the more it benefits you. But it's not required. When I submit a non-provisional, they're going to look at it and say, you say you have 7 drawings, guess what? I only found 5. And or you do have 7 and you've only described 5, and they're going to go through all these things and say, are all the parts here? And if they're not, they're going to kick it back and make me fix it. With a provisional, they're never going to do that. So if you're missing anything, it's going to hurt you or could potentially hurt you. But the patent office isn't going to fix it for you.
Also, heard you say something about making copies of your notebook
You can do that.
to file with the provisional?
You can do that, and as a matter of fact, this week I worked on one where we cut pieces of it, literally, with a made copies, used a program called Snagit where you can pull pieces out, and plugged it in where he had done data and things like that. Put it right in the middle of the specification because we wanted to do something quick, didn't have time to create tables. So we literally took, portions of a PDF, stuck them into the provisional patent filing. By the time you go to the utility, you're going to want to make that the correct way.
And if you have an orphan patent, or orphan, what do you call it? You want to file an orphan patent?
Orphan.
Isn't that what they call it?
Often?
No, where you're filing something that is beneficial to mankind and get a reduced rate. I think the lady up here.
like
that
orphan drug
was,
application.
yeah, that's,
So
Not a
that's
patent.
only for drugs. It's only
Only
for
for
drugs.
drugs?
Yeah.
There are some reasons that you get special treatment. I believe green energy is another one. In certain cases, if there's health implications for the inventor, they're very specific, but you can get special treatment for some of those.
The patent office has, you can actually talk to the patent office and they have ombudsman, say that word there.
No, you
But
said
that will help kind of first-time inventors. If this is something that you wanted to do on your own, you can actually call them and they will work with you as a solo inventor to kind of go through the process. But they won't give you really legal advice. So I think, like you were saying, it's best to kind of get an attorney in the beginning because otherwise you're kind of, it's a lot to take on and a lot to learn and it's a special field and
You
why
could
we're
hurt
here,
yourself.
right?
You could actually
Yeah.
say something
Right.
that would be
So-
better if you never filed.
Yep.
Thank you.
Okay. I think we're okay. I'll be around.